Hello, my name is Michael Comorn of Comorn Law, PLLC. Today I want to talk to you about the Fourth Amendment, or as what we sometimes discuss in my office, the challenges of being a criminal defense lawyer and practicing law in Michigan when there is no Fourth Amendment. Why do I say this? Well, this topic comes up quite a bit in our practice as it relates to medical marijuana patients and caregivers that are cultivating marijuana for medical use, and the interplay that it has with the Fourth Amendment, which protects citizens against unlawful searches and seizures. Michigan has not been advanced on the protections of citizens in their home or vehicles or traveling, walking around on foot, and this is exemplified in the way in which the courts have dealt with medical marijuana patients and caregivers who are cultivating marijuana and the Fourth Amendment. The one case on point, and this is important to understand the issues that interplay here, rejects the premise that a patient or caregiver who is cultivating marijuana and is authorized by the state to do so has any protections above and beyond the existing law prior to the Michigan Medical Marijuana Act. What do I mean by that? Well, traditionally, law enforcement officers, when they're seeking a search warrant, need to provide probable cause of a possible crime taking place at a location that they want to search and seize property in. They will articulate in the affidavit the evidence or observations that they've made. These usually include things such as snow melting on the roof. They'll do a trash pull. They will discuss how there's air conditioning units or the electric bills are high or the windows are blocked out. They're all traditional things by which you'd find in any affidavit regarding an investigation for quote-unquote illegal marijuana cultivation. Now, all those things that I just mentioned are things that are authorized by the state for patients and caregivers to do and engage in. In other words, the definitions outlined in the Michigan Medical Marijuana Act and the specific protections for the medical use of marijuana unequivocally include making the smell of marijuana, burning energy to grow your plants, the snow melting on the roof, and even discarding things associated with that. However, when given the chance to rule on this and protect the class of people that we're talking about here, the Court of Appeals instead decided to punt. And the only case addressing the Fourth Amendment to date, in the matter of the state of Michigan versus Anthony Brown, the Court of Appeals said no. Law enforcement does not need to determine whether a suspect or a house that they want to get into is a patient or caregiver. First, because purportedly they can't get into the registry because it's private to learn these things. And secondly, as has happened in many cases by our courts, the court has found that the MMA did not alter, amend, or change in any way the public health code, which are the laws that prohibit any marijuana activity. Instead, the MMA only provided, according to these opinions, protections for a limited group of people, small class of people. And that's the status of the law to date, and the only case law that commands this area. And that's why we say that it's oftentimes difficult to practice criminal defense when there's no Fourth Amendment, because the Court of Appeals has completely ignored the state-authorized behavior as being something that is lawful and has allowed rulings to stand where that same authorized behavior is deemed probable cause of a crime. Why is this important? Because, as we find in our practice, there's often times where there are police encounters with individuals that are patients and caregivers. The information I just described is very important for you to understand why the advice I am purporting you should consider is a proper path when you have a police encounter. Now, because of the fact that law enforcement has no duty to determine whether or not you're a patient or caregiver, as they may be investigating you because of a tip that it smells or some other occurrence that brings the attention of the police to your house. If you have an encounter with them, the most important thing for you to understand is that you should not make any statements other than what I'm about to tell you. That is to say, when you have law enforcement encounters and you're being investigated and you sense that they're trying to extrapolate information from you, or it's even a friendly encounter at a road stop, remember, anything you say will be used against you. So use your words carefully if you are going to, but best bet is to not say anything at all. Now, if you have this kind of encounter at your residence, where the police knock on your door and tell you that they're there because they got a complaint about marijuana, The first thing I advise you to do is remember, don't talk, don't say anything, other than the following. You should be prepared and have near the front door and have accessible to you at times when this kind of event is taking place, to be prepared to hand to the officers that may be there at the door your medical marijuana patient or caregiver cards. While you're doing this, you should be contemplating the ability to record this event. Maybe turn your phone on and record, take a picture of it. But the way it should go down is conceptualizing, being able to take the cards, hand them to the officer, and videotape or take a photograph of that particular transfer. This is evidence you're collecting of your compliance. And when you hand it to them, you should say the following words. My lawyers told me not to talk without him or her being here. And my lawyers told me I shouldn't answer any questions. My lawyers told me I should not consent to any searches without a search warrant. My lawyer also told me to give you my medical marijuana cards so you know that I'm a patient or caregiver and in compliance with the Michigan Medical Marijuana Act. And that is it. Nothing else should be said. You should leave this event with a photograph or hopefully a movie of some kind. And that is how you should respond to encounters where there's a knock, what's often described as a knock and talk, or the police appear at your front door. Also important is, do not let them into the house under any circumstances. Speak to them through the door, and if you're going to hand them any documentation, you should step outside, closing the door behind you, making it clear that you are not giving them any entry or access to your house. Additionally, and most important, is the following. If you are a patient or caregiver and have an encounter with law enforcement, understand that they have no legal authority whatsoever to do a compliance check. More and more we are hearing that drug task forces are appearing at people's residences and getting consent to search the residence under the pretext that they're going to do a compliance check. Understand that this is a falsity and a method by which law enforcement is using to get into the location, which is a false premise. Let me make it clear. There's no legal authority for drug task forces to determine your compliance or check for your compliance as a medical marijuana patient or caregiver possessing plants. Don't let them fool you and consent to this search. It will not work to your advantage in most situations. And finally, this advice is advice that is gleaned from experiences that I've had with the law enforcement community as it relates to patients and caregivers. There are some, I understand, positive law enforcement encounters that exist and have existed. My advice is not based on those scenarios. They're based on the people that have called their office and have had negative interactions with law enforcement that resulted in felony charges and what patients or caregivers believe would be behavior that would be immune from arrest, prosecution, and forfeiture in the seizure of all your property. Instead, they found themselves in court. Based on those calls, those clients, and those experiences is where the advice that I'm proffering you to consider, that's where it comes from. And just to summarize, I don't believe we're at a state yet where we're trustworthy of the law enforcement community to, or give them the authority to be the judges of compliance. The last 10 years, they've been very slow to come around to recognize some of the basic, fundamental principles of the Michigan Medical Marijuana Act, specifically things like what a plant is, what's usable material. I don't think that they've earned the right yet to be trusted to come in and determine compliance and let people fix or come into compliance yet. I think what we're seeing, and the reasons why I'm proffering this advice is because more and more, if you are out of compliance, the way that it is reacted to by law enforcement is they deem that you are not immune from marijuana behavior, they will felonize you, and they will seize your property. Those are the circumstances that are in play. And my advice at this point, until evidence proves otherwise, that advice should be given differently, is that when you have these law enforcement encounters, remember, number one, don't talk to the police. Number two, be ready for these encounters. Have your cards available at the front door or where you would have this encounter with law enforcement, or have them on your person, and be prepared to hand them to them with the following words. My lawyers told me not to speak to you. You're not allowed in unless you have a search warrant. My lawyer told me to give you these cards and let you know that I'm a patient caregiver that's in compliance. If you follow these directions, the law enforcement community or the people investigating should understand that they don't have, or what they believed was an investigation that may garner probable cause, that they don't have it. That exchange, the way I describe it, should minimize their thoughts and or concerns regarding a crime taking place. In other words, the smell of marijuana, if that's a crime which is deemed so, or suspicion of a crime, that is alleviated upon the presentation of the card. And the probable cause they may have thought that they had to get a search warrant would not be there if, in fact, the officers are honest, and you would have the picture and photograph or small video, short video of the encounter where you handed them the cards. And they would have no reason to think that there's just a smell of illegal marijuana, when in fact, after this encounter, they would know that you are a patient or a caregiver, thus vitiating what would be suspicion of a crime. I think following those principles and being ready for them is advice that will help you in the long run, and hopefully create a positive police encounter, or at least create a situation that, should the police respond negatively to you, you'll be in the best position to defend the search or attack the search as illegal. My name is Michael Comorn of Comorn Law. Thanks for listening.